It is therefore my condition that the witness cannot be declared a hostile witness, whereby he gave evidence and proper evidence. That's what it is.
No, Church simply shall pele ngupela hororo hlazi vele ayiluwe hlazi la yomuri ifile buhlazi we ifa buhlazi we ngoro thulana le buhlazi ba bona be moemedi wa molato fatso wa mathoma ya mopela horo a re ka tsela e feng ba lekile ba tse gopelo ya mathomo gopelo ya mathomo ya hanetswa ba le ka o tlisha gopelo ngwe mo ile ngore re lebele ke tlhatsi e le ngore e file ba ibisha dipitšo arabe dipitšo ka go tshwantse di arabe ka ona ejere le kana aba bontsha mo pele ga go gore aowa a ya sona o ba bia lo ka mogolo o motho se o gopela ka ona
tanto ano ja se on my own amulo on ma o pa la ta na o sa sine o ta ke go fa no ta ni mo na no o ba ni o ja ko ma ko stop la session e ni a ve na yo pa ta ni mo pa ta ni la o ja ai ne na o to stop la session o ba yo ka yi ushi ka ya mo na ko fa yi pa mo shi mo to mo ta e so ba ni yi ushi mo fa ma ka ai se ni se ni o ta ni o te ko te se ka ta ni no o fa ka tshwe ta ko tshashite uja onima o mbangi ta ni ta ni na ni ko se o mbangi na ya ke sino wata ko mbangi ni wa ma ko wata ko kwa ni mbangi na ke sote ko tshite o ba ti o pa mi bo fa o se ta ni ke uja ko te ko shima ti ba
Maybe the water but no need to repeat the submissions made by the colleague for number one. We are in support for this submission.
So both of you are saying if the
raise this issue with the state in the last period to say if you have a problem with the evidence, at least invoke the provisions of but if the state chose not to.
So I must refuse them that opportunity if now they are approaching the court with a relevant section. I said no, I must say no, because previously you didn't want to apply this one, you cannot apply it now.
On the other basis is that there should be a ground at least that they could. But what do I say is
There should be.
the basis for them to say he's a host.
He says with the same facts that we previously raised, I therefore apply in terms of section 190.
But now let's look at the evidence of the witness. The witness in giving his evidence, there wasn't any time that the witness has refused to answer a question that was raised.
There is a difference between section 189 and section 190. Section 189, the one that I have dealt with, I have made it very clear that the witness never refused to answer any questions. That one is very clear. So we have passed that particular stage now. We are now coming to another section, which is section 190, for which the state is basing its application now. There should be difference between the two sections. I'm sorry? Oh, yes, you are welcome.
The state submitted to say the witness made a statement to the police and he has now deviated from that statement. And in this evidence, the witness has indicated that I was threatened, and a whole lot of things happened prior to this statement being made. Now, a determination has to be made as to whether this statement is admissible in evidence. That's the one fact. Now, in the event the court says that this statement will be admissible in evidence, now we're looking at was this statement made freely and voluntarily or not. All those comes out to be looked into. But now, looking at the state of the state's request at this stage to say he has deviated from the statement he made to the police, which statement has not as yet been determined to whether to accept an evidence. Now we're looking at the evidence that he has given as he says. Now ask ourselves a question from there, that was he hostile, that he can be declared a hostile witness. And if we look at the provisions there of section 190, it's mostly dealing with the credibility of the witness, as whether the witness can be impeached. And this is our submission from where we're sitting, that we do not see from the evidence that he gave, that without looking at the statement, looking at the evidence that he gave before. It's our submission, Your Worship. I wouldn't make much submissions on this fact. I have not fully prepared on it.
I'm sorry?
I wouldn't make much submissions except to state what I've stated. I have not fully prepared on that application that the state has just made.
Do you want to prepare? I don't want to prejudice you.
No, I think what I've submitted.
Yeah, then you must not say I'm not fully prepared. If you want to prepare, says to me, I'm not ready now, can we adjourn for 10 minutes or so that I can get prepared? I don't want to prejudice you.
I agree, but I don't think that I will need to adjourn.
Yeah, then you mustn't withdraw the way to say I'm not fully prepared. You are prepared. Yes. Thank you.
Moemedi wa mona tlhasho wa bobedi wa boraro wa bontshe mo pele ga gore yena a lebeletse tlhatse a se tlhatse le mo tlhomile ya tswa kwa o tlhatse mo ileng gore o yeme ka mo letlhakoreng la motšhotšisi ka baka la go file botlhatse ba hae a araba dipotso ebe re sa lebelele statement rena re bolela re lebeletse botlhatse bo e leng gore o tsweleditše mo pele ga kgoro.
Any response?
Thank you, Your Worship. Your Worship, I think it's a question of conflicting issues. The two sections differ and they serve different purposes. And the state can rely on either or both of them. I don't think the submissions made are supportive of the witness not being declared hostile. Because being a hostile witness means being a witness who is not favorable to the party calling, and that's what the state has shown to this court between the viewer of the evidence and the evidence that he was called to adjudge in terms of what he has made to the police. And I think the state has made a good case that will just be declared hostile.
Mina motšhotšhisi wa bušeletša gape mo pele ga kgoro gore melao yeo e ka lebela ke melao e leng gore e fapane e leng gore e ka šomišiwa ke botšhotšhisa ba bontšha gore wa bona bontšhe mabaka a e leng mabaka ona a bontšha gore tlhatse ya bona ke tlhatse e leng gore e tswile o ba e bathege mo botlhatseng ba bona ba ba nyako go tšweletša mo pele ga kgoro.
When the state made an application in terms of section 189, subsection 1 of the Criminal Procedure Act, on the basis that they have provided at that particular stage, the court also raised this particular section 190 of the Criminal Procedure Act, which deals with declaring the witness an hostile, so as to give the state an opportunity to cross-examine the witness if they are of the view or opinion that he is deviating from the statement that he made to the police vis-a-vis his oral evidence in court.
Ile ya bontsha ka morao mo tšhotšisa tse kgopelo ya molao o tshwanetse o lebelle wa 189 89 ya bontsha motšhotšiši gore o na le molao wa 189 o ka lebela gore tlhase yone a kgone o ka fetola dipušo ka baka la gore o ntšha o kare o tswa o ile mo botlhatseng bona o e leng gore o file ba statement le bo a bofa mo pele ga kgoro
I wouldn't want to prejudice the state under the circumstances. I'm of the view that they may be entitled to cross-examine the witness if they are of the opinion that he is deviating from the statement which he made to the police.
gore ya bontsha gore a nya go to bia motšhotšiši mo seemong se e leng gore ga se sa maleba e le gore wa bona gore o tshwanetse o ka buša dipušo ka statement se e leng gore o se dirile mo godise tshwanetse a dire bjalo
Which evidence is accepted at this is not for the court to determine which evidence is accepted at this particular stage of the proceedings.
nna mo lebakeng lona le bola tswele pele ga se mo e leng gore tshwanetse go lebelele gore na ke botlhatse bo bofe bo e leng gore gore o tshwanetse bo amogela
Some of the evidence may be true, some of the evidence may be false, but the totality of the evidence should be considered at the end of the trial when the court is to give a judgment.
bo fošagetse bo ngwakara le gore ke bannete bela botlhatsi bo ka moka botlotsiwa ka moka gore ya bo lebelela check o setse e fedile go tlo fitlhela mo sephetho se e leng gore se tshwanetse
For that reason, the application by the state is granted.
ile ba bontsha mo ka morago tseo kopelo ya motšhotšiši e dumeletswe
So, Mr. Tagale, you recall that the reason you were summoned to appear before this court was as a result of you having been lined up as one of the state witnesses in this matter.
are wa go le baka la gore o feletse o biditšwe mo ka le baka la gore o bile o biditšwe ka baka la gore o tlhatsa kere e leng gore e biditšwe ka matlhakore la batšhotšhisi go bjalo that is correct
And during the proceedings on the 17th of September 2025, the state brought to the attention of the court that the evidence you gave does not coincide with the statement that you deposed to when you made your statement to the police.
ka tšatši la di 17 ya september ka ngwaga wa 2025 ke re motšhotšiši ka tlhaiša mo pele wa gore gore botlhatsi bo o fanga ke a se botlhatsi bo e leng gore bo sepedišana le botlhatsi bo e leng gore dile ka statement mo pele ga maphodisa
And you confirm that the contents of the statement were made by you to the investigating officer who produced your statement to writing and signed by yourself.
wa conditional statement se o ke se wona o soletseng ke re sengwala ke le phodisa le dirang dinyakišišwa ke re ebile wa balelwa sona wa se sign.
Yeah, ma'am.
That is correct.
And you confirm that, as contained in paragraph 4 of your statement, when you made reference to my guy, you were referring to acting number 1.
Ebile wa go tšhišiša gape le gore mo statement mo paragraphong e leng gore wa bontšhitše mo yona ya gore maika eno o ra molatla jwa mathogo.
Yeah.
Your Worship, we just want to raise this issue in the procedural aspect. The statement, what we're dealing with now is a statement that was dealt with on the previous occasion at the time that we were dealing with Section 189. And the court has made a ruling as far as that section is concerned. We're now dealing with the Section 190, which the court has granted that the statement and crosses mine. But now, isn't it proper that that statement that is going to be, that we're going to be dealing with ought to be proven to be presented or that has,
I don't understand.
that the statement that now we're going to be dealing with, the Section 189 was there and the court decided on that.
Was the statement not given to the witness previously?
Yeah,
Did he confirm that statement?
that is what we.
That is the statement made by him.
By him and all the requirements that are needed.
What's the problem now?
We see him starting to deal with the statement without first dealing with those issues, whether the statement the free intelligent weight and whether it was coerced or all those aspects. Those were
Was it not dealt with previously?
not in this context.
You are overruled. You may proceed. You may proceed.
Thank you, Officer. You will recall that when this statement was presented to you, I drew your attention to the fact that in the statement you provided to the police, you made mention of the fact that there was prior arrangement between you and accused number 1 regarding transport, contrary to what you said in the evidence in chief when you said you just met there by incident.
Maro sa o bola ke re ba ile ba o lemoša ke re gore mo statementeng sa gago o ile wa bontšha gore le boletse pele la beakanya le molatlafatšo mo ka taba ya transport wa kere bjale mo e leng gore o fapana le botlhatsi bo o file mo pele ga gore o ile wa kopana le bona go kopane le bona na pele a bolela ka taba ya transport a ro sa o bola seo.
You remember that?
Maro sa o bola seo.
Ke sa gopola.
Yes, I still remember.
So how do you explain this difference? That there was prior telephonic arrangement that you made there and you require transport, and in your evidence, in your oral evidence, you changed that version.
Fela we tlhalosa bjang phapano e or pharologano e nngwe ya o ile wa beakanya le bona mo founung wa ka taba ya transport la kopana kowe le botlhatsi bo boletse mo pele a goro kopana na kowe la bolela.
es ke boletse gore taba e ke ya gale ke dingwe a ke sa gopola because of dilo tsa gona ke tša gale. I cannot recall very well gore eng ke eng mara ke dingwe ke ya gopola.
Okay, as I had indicated before, that some of the things as they happened some time ago, I do not recall them, but others I do recall them.
In your statement, you also made mention of the fact that my guy, being at number one, directed you to a farm 20 or 30 kilometers outside the arena, where he took you to a small segment where the Namibian people stay. And you later got to know this place as Fengerpra.
Really, the most statement, I want to my guy, we allow more 30 Gabriela, more from Wayne, Timothy, but when I was Namibia, Camera, what I was all playing 12 finger.
In your evidence in chief, you selected to leave action number one in town and not travel with him to Fengerpra.
If I was a little bit Mulatfata or Matomaker or Mutwiji, rather my lane area when I go finger.
And that is unlike what you explained, your explanation earlier on that you have forgotten certain things. This can't be about forgetting, it's all time. Well, how do you explain that?
I'm going down. I say, oh, the villagers start you kitchen, Jody Levitching. I can know what's from Moon, Judy Kisha, Mola, and old Halusaga.
How do you explain
that? We can't surrender.
Es ke boletse gore ba tlile ba re kishe ba le kwa ge ile ge yena a shala tropo a ya le rena mo plekete.
As I had explained that they came and said that I must transport or take others to where I had taken them. We did not go with him. He remained in town.
Yes, how do you explain this difference that is there in your statement and what you said in your oral evidence? Maybe I should end by indicating to you that there will be evidence that will be presented later on that will also show that he and the two went together to Fengerpra, contrary to what you said in your oral evidence.
Na go fapana ha botlhatsi bo o wa statement le bona bo e ba bontsha gore o boletse ka molomo o botlhalisa bjang ka baka wa motho go ta botlhatsi akere ka mora o nyana ba o bontsha gore molatfatso ena wa mathomo le ena o ba le hona le batho bona ba ba ishiwa kae Fengerpra.
Es ke boletse ge re ya a ba se gona but ge ke ba lata e ba le ba bararo.
I was seeking them there. He was not there. He was not with them. But when I went to fetch them, he was with them. There were 3 of them.
What do you say about the fact that evidence will be there to show that the 3 left together from contrary to what you are saying?
Ge ba rona le botlhase bo tlotlisiwang gore o ba le gona ba ba bararo ba tsamaya ba ya fengerekrala kere o fapana le se wena o se bolelang.
Your Worship, this would be unfair to the witness in the sense that the witness will not know what the other ones are going to say. The witness has said what was needed to be said.
Just a minute. Do you have the statements of those witnesses? The one you are going to call?
That will be the evidence of, yes, the statement that is accompanied.
The name of the witness, if the defense has that statement, I just want to determine.
The cell phone reports. Sergeant Nkosi.
I'm sorry?
There is a Sergeant Nkosi who compiled cell phone data. They are in a position thereof is the witness who will testify to this aspect that I'm talking about.
It must be very clear, because if now I allowed you to cross-examine, and it must be clear for the benefit also of the defense, which witness are you referring to, so that they may also know which witness you are referring to, to look into that particular aspect.
Maybe let me just phrase it
Yeah.
with the correct details. Sergeant Nkosi will be called to testify, and he will testify to the effect that through cell phone maybe, action number 1 and the 2 other people who was in the company proceeded simultaneously at the same time to penetrate the area, which is contrary to what you asserted that you left action number 1 behind.
Botlhatsi ba Sergeant Nkosi ke bo e leng gore tla ba botliša bjalo ka record tsela tsa difounu ke o tla bontšha gore molatlo jwa matho le ba le babedi ke ba tsamaile ele botlha ke o bo fitlha ona go fengerekrale ba le botlha ke ebile botlhatsi bo fapana le bo wena o sa tšong go bontšha pela go
Your Worship, the state now is dealing with evidence that is forthcoming and not cross-examining the witness on what he said previously, on their evidence, not on anyone's evidence. It is also still unfair for the witness to know what the cell phone data is going to say, unless if the state had taken the very witness through that cell phone data and the witness statement. So actually, for this witness to know what is forthcoming or what somebody is going to say, it's a bit far-fetched for the state to be saying that. So it is best for the state to cross-examine the witness on the statement that he made in court, evidence in court, as well as the statement presented to court in the form of a printed statement. So actually, it is my contention that it is basically unfair for the witness to know what other witnesses are going to say. So the state needs to be careful and consider what they need to know based on what the witness has said, not on what somebody is going to say. Because it seems they are now forcing the witness to consider somebody's statement or to weigh his evidence versus the one who is going to testify something else that he doesn't know. He said it, the first question answered. The 2 went, number 1 remained.
You want those witnesses to come and testify, then we recall this witness so that he may be confronted with what these witnesses are saying.
The purpose of cross-examination is just...
Yeah, my question is, if you have statements of witnesses that will be called as witnesses, and now you object to the state to raise what is in those statements. If I said, yes, the state, you are not allowed to raise that, let's wait for this witness to come. I excuse this witness, so we must recall him so that they can come and cross-examine him on that.
I'm not saying that.
What are you saying?
I'm saying, for now, what the state needs to do, because the witness has given answers, right? And then in those answers, which are very, very...
I don't understand your objection.
What I'm saying is, Your Worship,
What is actually your objection, Mr.
our
Matlala?
objection is, Your Worship, now the state is bombarding the witness with everything that he does not know, and he keeps giving one answer. From the first question, he gave one answer. Now the state is again repeating on one question, trying to say to the witness that he deviated from what he said. So we cannot say that allow the state to just continue on one question, looking for...
You are raising another issue now, not the one that you were previously raising. Please raise one aspect so that I can understand it and confine myself to it, please.
Your Worship, what I'm saying basically is the state is now bombarding the witness with evidence that is to come.
Thank you, I've heard.
Whereby the witness has already answered the state. It is 3 or 4 questions that are answered. What I'm going to say with this evidence that the 3 went together at the place. He said, no, when I went there to fetch them, there were 3. But when I took the 2, it was only the 2. Number 1 remained in town. Still comes again and said, no, what an officer also, Sergeant also is going to say the 3 went there simultaneously. But he already answered. He said, no, now I left number 1 in town. So the 2 were there already. But when I went to fetch them, there were 3.
Yeah, that is why I'm saying I don't understand. What is your issue? The issue is that he has answered the question, the state keep on repeating one and the same question.
Yes.
Or the issue is the state is not entitled to ask him about evidence that the state is still going to lead through witnesses who had made statement. That is why I said you raise 2 issues, please. You must tell me which one you stand on so that I can give a ruling.
The issue is
Yes.
that this witness has already answered.
Oh, thank you. Oh, not that he cannot be asked. Yeah, that is why I'm saying I didn't understand you correctly, Mr. Matlala. State. Yes, let's have progress. Don't keep on asking one and the same question for the sake of progress. Thank you.
And you said that the following morning, when you picked them up, they were 3. Do you perhaps know how option number 1 got to that place?
ile ba shorna forwards borna akaba fitlile beng ko plekeng yone yo molafi jwa matlo
fa re wa tata bona go ja o ke wa ke ja se ke nya wa tsona go ka ke ba na do nya o no ke o te jwa ja okay to no no go go ba ja o ke lo go ba ta go ga go ne
ke tsebe rena ka ba fitlile ba mola.
I do not know how he got to that place.
Did you perhaps ask him, since you were the one transporting the other two to that place, or will be there?
We don't want Muchisha. Abala, when I will do young, whatever video we shall not go with or Mushamra.
I think ke mmutsisha ke re a ba rile ke sheba le ba bang mola plekeng.
I did not ask him because he's the one who indicated that I have to transport the two to that place.
I want to read to you the contents of paragraph 13 of the statement that you made to the police and to the
Naranya ko ba like paragraph ya 18 ya mo statement in say gore sile mapodisa
and that was when you were in Binoni in Gauteng.
bare ke mo karolong ela o beng ole ko Binoni Gauteng.
In that garage where you said you arrived early in the morning before they could even open.
Mo ilong wa wonchora wa wina fitla ke rona mo garageng e sa le foro ba se tshula mo ile
And he said, now that they had transport, they said that I could go and they will drive further with this car.
mo ilong wa wonchora awa ka ile ba re monna wa ka rone se tsofetse ba ra wena o kana hae bona ba tla no tswela pele ba tsama ka koloi ba subelela
I think you recall and confirm that statement. That statement that they said they will drive further with their car.
ba re se o mo statement gore ba tle mo yona rawa nna re tla tswela pele ka leeto la rena ka koloi
Ke go ntisha le gore ba nna ke tsamaye bona ba tla tsamaya ka re ba ne le koloi.
I did confirm that because they indicated to me that I can go. They will proceed on their own as they have their own vehicle.
I heard the three talking their language, and then the one that stayed behind in my car took out cash from his side bag, and at this point I noticed that it was 3 packs of US dollars.
Ara na bile wa ba kwa ba ba bolela ka le limele la ko bo bona ya ba ile gore o ba shitse bona ka mo koloing ya ba shule o ntsha tšhelete ba re cash akere ka mo side bag ya hai ya ba le wa bona ba re ke di bag je tharo tsa di US dollar
And they told me that one pack was 10,000 US dollars.
le se tswela pele se bontshwana le ba o botsa gore packet e tee e tshwereng ba re 10,000 US dollar
Do you recall that?
maro sa gopola se
le ka bušeletša gape a ka kwa botse.
can you repeat that because I did not hear that properly?
That the one that was sitting behind in your car gave you 3 packs of US dollars, which were 10,000 each pack.
Maro wo na di tšomora wa kere ora na še mora ka mo community akere ya hao o ile a diang a ba ra se sharp side pack a se sharp side pack ya ba lo mtšhaking ke mekota e meraro dipakete tše tharo dipakete tše tharo tše ileng gore mo ye teng e be e na leng le 10,000 US dollar.
Tšhelete nna ke e filego e be e le 7,000.
The money that I was given was an amount of 7,000.
In paragraph 14, you said, I then followed Wasim to the casino.
Just a minute. 7,000 rands or dollars?
Rent.
Rands.
Yes.
Rents.
You may proceed.
And in paragraph 14, you said, I then followed Wasim to the casino where he took 1 pack of dollars and went inside.
I ile swela le sa bontsho re ile wa shala morao ba ke mang wasing la ya ka mo casino le fitla ka mo casino ancha packet or packet ya di US dollar.
What's the comment on that?
Maro re nka sewe se bontsha mo statement.
Casino re a tšwa, but the tšhelete ke e fileng e be e le 7,000 rand.
We did go to the casino, but the money that I was given was an amount of 7,000 rands.
So what were you going to do at the casino? You were given 7,000 rands, South African rands. What were you going to do at the casino, sir?
Har wana no ilodi yango casino nka ba ka re tšhelete o fileng yona nkere ya ka mo South Africa ke ile 7,000 rand.
Mola casino e be le ge yena a ya casino, and then ka ya le yena from there ya ba ge nna ke tšwa ke namela tsela ke le ba gae.
Okay. There at the casino, it's where he went and entered. And every time that he entered inside the casino, I entered with him. Then after, I got out of the casino and then went home.
You say when he went to the casino, what are you referring to Wasim?
But he already tsana ka mo casino ora mahora
Wasim.
Wasim.
Yes.
Yes.
Master Father, you had no business with Wasim except to assist you in changing the dollars, because Wasim was an employee of the dealership that was interacting with accused number 1 and his 2 other friends in buying cars. The only purpose you could be with Wasim was for him to assist you to change the dollars into the rands.
Wana no sina business ya ke rona kwa we dirang le Wasim ka ntle le yang lo tsana le ka mola yo change US dollar
What is your comment?
Statement sela.
Can you repeat the statement?
You didn't know Wasim. You had no business with Wasim. Wasim was an employee of that car dealership where number one and his two friends were buying cars. The only reason you and Wasim could go to the casino was for him to assist you in exchanging the $10,000 into $145,000 cash.
Naro wena kasi but mahasimi no samutseba kere no sina business over for wele na we dirang business ye ya bileng ona le batho ibele mona tshwara mathomo le ba bangwa ke ba kana go bereka go dikolo imo ile ngoro business le be taba ya go le ba la tshwara pelo ra wena kopane ha ele yena be le taba ya ra di a change $10,000 e change o di ranta ka mo casino se wena le ena le se le go bantshitse
Wasim ke mo tsebile mo la garage es ke boletse kare re tlogile ba ile go tsamaya ka ya le Wasim casino from there ya bare ke fiwa tšhelete ke tsamaya a fetša go fiwa tšhelete ya bare ke nna ke tsamaya Wasim a jala casino.
Okay, I knew casino from the garage because I went with him inside the casino. Then I was given money. After being given money, then I went home.
The money was given charity before the casino.
Okay, and then the money I was being given before entering inside the casino.
Before
going.
Before
Ria.
Yes.
Ria.
Before going.
Before going to
the casino.
Yeah.
And you went further to say, I cannot remember the date, but much later in the year, I contacted Wasim and went back to Binona where he assisted me in exchanging another $10,000 into $145,000.
Maybe lo wa bontsha ke re le mo statement o le ra sa o kula ke or ile leng if you like ile ka diang ba nya le Wasim ke mo elong ile ka ya binoni mo elong lo chila chelete hape ya $10,000 or $140,000 rand.
Es ile ka bolela kwa morago kare bula go ba le batho ba ba tlang ba ntšhošetša so ke dingwe mola e be ke no bolediša ke taba ya ge e le ke sanya ke go šiwa letsogo because of go tlile batho ba ile gore ke magoa ene e be re kwa mo social media gore go ile go ba le batho ba le gore ba swara batho mola pleke ela ba ba iša matsogo.
Okay, as I had indicated before that I was threatened. Some of the things that I've mentioned because I did not want to be laid a hand, and because the people who were coming there to threaten me there, some of them were white people, and I also heard from social media that there were people who were being arrested in that area.
But it is yourself who made this statement. The statement was made by you and not by those people who
mare fela statement ke re ko wena o se dirileng a sa dira ke batho ba o bolelang ka bona.
Ka tloana statement a seo a njane o be mo shiniba statement ya shina shiniba ko ambenya ba lo ka.
Statement se dirile ke nna yes ele ge ke se dira ke le ka fase ga letshogo ka ge ke boletse ka re go tlile batho ba fapana ele ge ba nyaka ba nthreatena ba re ba nyaka accused number 1 ke re a ke tsebe gore o kae.
Yes, that is correct. I'm the one who made a statement. But when I made the statement, I was scared, afraid, because they came different people who indicated that they are looking or they want accused number 1.
O shi statement ana shi anja ya statement ke shi anja kwa ndi ko shi yumba ya ni ko ya ba shashi ne da shi ta shashi ta ko mu ta bala on ke ba wote to ko ne ka statement ta shashi kwa ndi shashi ko ma ko shi yumba.
Yes, the fact that the people coming, that doesn't make your statement to be false, because they did not dictate to you what to say, but this is what you told them because of the knowledge that we have about this event.
Mara gore batho ne ntse ba etla ka mgobelang ka ona re ba tlile ka go fana ga bona se wa sara statement sa wa kere se foshahetse a kere statement se ke se leng gore wena o se boletse ka bona wa fa sona o ba tlhalosetsha ba se ngwana
That is one of the statements showing the problem okay,
No, finished with the witness, please.
And you further said, I was shown a picture by Lieutenant Colonel Schneider and I recognized this person on the picture as David.
ile wa tswela pele o bontsha gore o ile wa bontsha senepa kere ke lieutenant or Smith wa kgona mo lema motho o gore ke David.
Jumata wa kwa mtia kwa ni wa ukule pana efano la shoro o no wa efano wa ni la kompoliti o kujana o ma shoro e na la David.
You recall that?
Ba ro sa opola se o
dinepe ke bontšhitše e le I think 5 or 6 pictures if a ke sa gopola gabotsana.
If I were to recall very well, I was shown only
5 or 6 pictures.
5 or 6 pictures.
O shilo ma ni mo ma ni ke ni kana kana papa pa ni ko wa ta ni ko mata ta ni mata ni ma.
I'm talking about the one that you said I recognize this person on the picture as David. The picture is attached as MM2 on your slide.
Ba re gona ba bolela ka senepe se le gore ba bontsha sona o se no bontsha sona wa awa o ya mgopo ke a mo tseba ora ke a mo lemoa ke David ibile senepe sona se bue se go madibjo mo statement ba re ke bile ke MWM2 mo statement ba bolela ka sona senepe se
Ta tu ane ko ma kana mo ko ni kana ni mo wa je kana lo wa je no mo wa shoro e David de utane ko ma ka kana la shoro ni to wa no kada hala ni la shamu ko ba ni wa o MWM2.
You recall that?
ba ro sa opola se
Ke sa gopola dinepe tše di bontšhitše ke di bontšhitšweng.
Yes, I still remember the pictures that I was shown.
And then
I'm talking about the picture that in your statement you said it depicts David, the one we're talking about.
Re ba bolela ka senepe ke se wena o bolelang ka se bontshe mo statement wa re senepe sona se bue ke se le gore se bontsha David.
That ko mo e fa no la ko ni ko wa tshela ko ni ko ni ko statement wa tshela ko shi o no
ea mara David wa gona e be se o ka go mo kry-a tšatši le ke ya kwa.
Yes, but the David is not the David that I found him on that place or on that day.
ko shi ma re ko shi da to mo ke te ni ko da ka sa na ko ni o
I think the court has already accepted the statement of this witnesses.
Where is that? The exhibit file, please. Where is the exhibit file? Any further question?
No.
You are through.
Yes,
We'll adjourn for 15 minutes, and when we come back, then it's for defense.
Re tlo nna ke re nyana metsotsonyana me 15 a ke
It is now 10 past 11. We'll adjourn and we'll resume at 5, 10, 15, 25 past 11.
re tlo ya re tswela pele ka 25 past 11 a ke
Mr. Takalo, you are still under oath. You don't discuss your evidence with other witnesses. Do you understand?
a re se ka lebala go sa le ka fasa kana a o tlo ya o bolela le tlhatse di mo tlhatse bo tswela pele ka bona mo khotho.
Okay. Ya kwešiša.
Understood, Your Worship.
Court adjourns will resume at 25 past 11.
Angoma kubi Siaya Siaya Loma kubi Siaya Siaya Loma bese kubula Besi shaya Besi bopa Loma bese kubula Besi shaya Besi bopa Loma kubi Siaya Siaya Kubi Kubi Siaya Siaya Loma bese tubola Besi shaya Besi bopa Loma bese tubola Besi shaya Besi bopa Who left? Who right? Come on, sir. Who left? Guitar. Kill him, man. Kiriwata. Tamarungo. Sorumormo. Asicha. Where were you when I'm drunk? Where were you when I'm sick? So fast, Kichi. Emoye. So fast, Kichi. Ekati. Kichi, Kichi. Kichima. Kichi, Kichi. Kichima. Onke laban. Emakit. Onke laban. Emakit. Seltatile. Elagit. Seltatile. Elagit. Shoot to kill. Namasa. Shoot to kill. Kill a man. Kill the poor, the farmer. Kill the poor, the farmer. Brr, pa, pa, brr, pa, pa. Shin. I repeat, kill the farmer, the poor. Kill the poor, the farmer. I repeat.
Right Mugeli we SABC lihaye konke okuqhubeka kwiphondo laseMpuma Koloni eMonti nalapho ke Mbukeli ngalentsasa siyesava inkundla isisho into yokubana lo kaMalema inkokheli ye-EFF unabo kaloku uyatyholwa kumpu awawuphathayo esidlangalaleni kanti ke Mbukeli uMalema uthetha nabalandeli nabaxhasi bombutho be-EFF nalapho esisho into yokubana bazawubuya ngamandla nge-23 kaJanuwari enkundleni uthi ke Mbukeli emva koko bazawubhena kwinkundla yomgaqo siseko kuba babona ngathi akwenzangwa bulungisa xa kuthabathwa isigqibo uyatsho kananjalo Mbukeli into yokubana konke oku kwenziwa ngujudge obonakala ngathi uba iyababukula ngobuhlanga esisho into yokubana eyona nto bayilwayo bubuhlanga obugqibayo apha eMzantsi Afrika uthi esigqibo sithatyathwa ukuze sichulumancise umongameli waseMelika uDonald Trump kananjalo ne-AfriForum ude ke Mbukeli ubalula nabalungu phakathi
Never different. Ko omi one what lingavi but a chinchichi. Asatla lola tlile na la matobo.
Okay, they were different people coming, but there is one person in particular who came twice with different people. The one that he did not come with them before.
You also mentioned that you, before the person who took this supposed to be statement, came to you and or you heard on social media that people were arrested and questioned.
Social media. Mo ilong gore pele ha he motho wa tla tlo statement ora tlo bushaka batho ba tshwere bile ba bushwa dipotsisho
Ila ka gore ke go jalo.
that is correct. I heard way.
And the person who said he took the statement that they came last, and you apparently did the statement who came after you have seen that part of the hand on that social media people were arrested.
Arena motho o kile ka mara go mola se jo go ilagere mo social media or a una le batho ba tshwere.
That is correct. And at the time he was interviewing you, was it at your free will?
Wa bicha gore ka na go ile mo ba ao interviewer o be o lukuluhile wa ile thato ya hao.
I wasn't free ka taba gore ke kry-ile call from ba re go na le baeng mo gae ne ke le mmerekong ka tloga Polokwane ka tla gae e ke tsena ka kry-a mago a mabedi.
I was not free because I received a call from home where they indicated that we have visitors and they indicated that it's two white people. Then I had to leave and went to Polokwane.
I was in Polokwane ka tloga Polokwane ka tla gae ge ke tsena gae ka khumana koloi tse pedi mo ntle a ke tsena ka khumana ile mago a mabedi.
I then had to leave Polokwane where I went home. Upon arriving at home, I found there were two vehicles and also two white people there at home.
Did they speak to your family before you came? Those two white people?
I will let you le family how family are going to pay I went off it.
It's a power of legend one. I get a human guy, Baba Philly Ditulo.
Okay, I do believe they had communicated with my family because I found them at home and they were given some shares.
What did they say to you? What did they ask you?
I never was sure now. Le mo wena wa go tshitse ba reng.
Ke tsene ka dumedisha and then ya ba gore ke just to look dula le bona.
I entered, greeted them, took a chair and went to sit with them.
ya be ke botsiswa gore ke nna mang ka ke tlhalosa
I was then asked, who are you? I explained myself.
from there ba mpusha the question gore ke tseba accused number 1 na
Then after that, they then asked me a question that, do you know accused number 1 or not?
ya be ke dumela and then ba re tlo just statement
I then I agreed. And after that, and they then said that we're going to take a statement.
so as re ntse ba dia statement ka letsogo le ge ke nagana gore tše dingwe e re di kwa mo social media gore go bile le batho ba le gore ba ba swere ba šitšwe ba bethilwe e le ge ba nyaka gore ba confesse before ba confesse ka taba go timela ka tšhelete around bela side.
Okay. While taking this statement, I was taking this statement being afraid in mind, thinking that on social media, I heard that there were some people who've been arrested and they were assaulted in relation to a case wherein they said that they took money. Okay?
In Bela.
Oh, in Bela.
You also stated in your evidence, before I go there, these 2 white people who came to you, was one of them the investigating officer in this case, Lieutenant Snell?
I'm sorry, who?
Lieutenant Snell.
Who?
Snell. Lieutenant Snell.
Snell.
Pele ba bushorna mo mo gona ma ya le ku atila kere ntse ba ntse go la ba dia just statement o mo bona ke yena mo next show mo la to ba Snell Lieutenant Snell
ke no be ke sa gopole maina a bona ga botse mara o mo wane o gona ka mo o ke mmona.
It's just that I do not remember their names very well, but one of them is here before court.
Yeah.
Prior to him coming to you, you were at some point handcuffed and taken to a police station. Is that correct?
Right?
Prior to Lieutenant Snell coming to your place, you were at some point handcuffed and taken to a police station.
Lieutenant Snell, I tla go go wena ke a rona le mo leng gore ile wa go kiwa wa go sno go kiwa isho police station.
Jwale ile ka gokiwa ka ishiwa police station ile ge go na le bana ba babedi ba bantsho lo mo wane wa legoa
That is
ba tsamaya ka BMW.
Okay, that is correct. When this was happening, they were 2 black men and 1 white. They were driving a BMW behind them.
Before you were informed that we are taking a statement now, were you asked as to whether you were freely and voluntarily making the statement?
Ba ka just statement mo wena ba ile ba go shorna a ulukulugile o ka wena o feletse re tswele pele ba ile ba go shase
Bada, you know, the way you are to Kwanja, or your statement.
Awa, aka utshišiwe gore ke free na e dubage ba rile ba re ba tlo tšea statement ka letšhogo ka dula fase ka comply.
Okay. No, I was not asked whether I'm free or not because of I was scared or afraid when they indicated to me that they are going to take a statement. Just complied with what I was told.
Was the statement handwritten at your disposal, or was it typed in your disposal?
Never one sure na place it me se singwani la gere mo pele ha we singwana wa se type mo pele ha.
E ba sa re laptop ba type.
Okay, they had a laptop and they were typing on their laptop.
And you signed the statement, of course.
Maria wona pele wa sign a statement o ya.
Are aba feature ka sign a statement.
After they finished, I then signed the statement.
Where was it printed?
What was the print local statement to say?
Nebasuri laptop, I think, small printer with them.
Okay, they had a laptop and a small printer with them.
Who was actually conducting that interview? Who was the leading interviewer at that point when you made the statement?
Are no just statement so kiman o we lo more o tla pele ke wow o etela pele o just statement se ba re ke
What I get a question ka mo o mongwe wa lekgowa le o mongwe wa lekgowa and then o mongwe a le busy a type.
Okay, I was getting the question from both of them, the other white police officer and the other one, while the other was typing.
Was the Commissioner of Oaths present?
Bare we lo mo wa commissioner o ba le hona
Except for those two that were there.
Okay. Bare ka ntle le ba babedi ba ne ba le mo o na le we lo mo o commissioner o commissioner statement. There were only two.
White
And they were both interviewing.
We di ba bona ntse ba bolela le wena ba o tsha dipotšišo. That is correct.
During the examining chief, especially during the last part when they were doing the application for, well, after you were declared hostile, you confirmed, just want your confirmation again, if that will serve correct with you. You were in Boxburg with number 1.
Is it Boxburg or Benoni? Is it Boxburg or Benoni?
Same place, same people.
Same place.
It's almost the same place. Close by.
I don't understand. The other name for Benoni is Boxburg.
I'm not sure.
Eh? Yeah, but where did you get Boxback? Because I must get clarity. I heard about Noni. If you insist on Boxback, just say Boxback. So
Our
that
phrase, Your Worship, our phrase, it just came on the top box because I don't place that book. You want to be Noni to a car dealership.
Mara o ile wa ya ndona ke o ba o re shwa dikolo.
ya go jalo.
That is correct.
At some point you went to a casino, but before that you were given 7,000.
Ona wa ya le ko casino a kere ba re fela da go tsara mo casino o ile wa fiwa tšhelete ya kere ye le mo ba re 7,000 rand.
ya go jalo.
That is correct.
And then you left. The
What?
place, you went back home.
Mara wa tsamaya ko plekeng e o dinoni wa ya ha.
The state was this inside?
Una le ntho e bolela?
No wa ka bolela ke tla bolela ka morago.
You can proceed. I will comment afterwards.
The state wants me to emphasize a point where it was said to you that in your statement you said you contacted Wasim to go back to exchange the US dollars that you had.
Ile ba re sa o pola gore motho thulanya go atella taba e nngwe ke ra mo statement ke re sela se dineng sa o ntšhitše gore wena o ile wa ikgokanya le mang le Wasim gore o kgone go boela marago dia mo dira exchange ya tšhelete ba re sa o ka se
I just want you to clarify me or to confirm. You were still at that particular time when you made a statement, not at free will.
which particular time?
When you made a statement.
Yeah, please, can we have progress, Mr. Matlala,
that's
please?
When you
Can we have a progress?
When you made that statement, were you at your free will?
Another question, please.
As a court basis?
Yes.
You testified earlier on that you took the two people to a place called Fengatara.
a re o ile wa re go o bontšhe mo botlhatse mare o jere batho ba babedi wa ba iša Fengerkra.
ya go jalo.
That is correct.
And you left the case number 1 in town.
Wa tloela molatlhatso wa motho mo ko toropong.
ya go jalo.
That is correct.
And the following day, you received a call from accused number 1 saying, "Coming, collect us our car was not, it could not fix our car."
Lo wa go tšhetse le le latelang molatlhatso wa mathomo kere a o founela ra wa itla o tlo re tšea ya se kgone go lokiša koloi.
ya go jalo.
That is correct.
And then what time was it when you received the call?
Mara nako e o kry-a kgolwa kere ne le nako ma
a ka nako nka sa gopola mara e be šetše le in the afternoon a re o ya ba gore batle ke tle ke ba tšee ge ke fetša show after the show ge e fela.
okay ne le in the afternoon.
Bona ba phone in the afternoon but ba re ge show e fela
Fela,
ke tle ke ba tšee.
Okay, just I don't remember what time was it, but it was in the afternoon. They had indicated to me that after the show is finished or it's done, I have to come to fetch them to collect them.
How many people there when you go to the
No, 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 to work, I owe you what? When I look,
ge ke ba lata ne ba le ba bararo
when I went to fetch them, they were 3.
and then at some point during that time you agreed about the price that they will pay you, how much to go to Johannesburg and Rustenburg.
Kana go la kwana kere ka go patela ka bokae ba re kwano go bile bokae patela go na mo ya Johannesburg e bile ya Rustenburg.
e re bile le kwano ya 5,000 ge ke ba bja Rustenburg, and then ge ba extenda ba re Johannesburg ya ba ge re change to 7,000.
Okay, we had an agreement that to Rustenburg it will be an amount of 5,000, and if you are going to extend above Rustenburg, it will be
Re kwana ka 7,000.
If you are going to, just a minute.
Rustenburg, it will be 5,000.
Yes.
If you exceed Rustenburg, it will be 7,000.
Another 2,000, 7,000.
No further questions, Your Worship.
Thank you. Any questions on behalf of accused number 2?
No question.
Is that- Yes.
On behalf of accused 2 and 3,
Oh, 2 and 3. Thank you. Thank you. Thank you. Any re-examination? No re-examination. Thank you. Thank you, sir. You may stand down. Yes, guest. State.
Thomas Mishiko.
Sir, come close to the mics. Thank you. Your full names and say name, please.
Thomas Nishiko.
Thomas Leshiko. Mr. Leshiko, do you understand what is meant by oath?
Yes, I do understand.
Do you have an objection in taking the prescribed oath?
I do understand. No objection, Your Worship.
Do you consider the oath to be binding or conscious, to tell the truth?
Yes, Your Worship.
May you swear that the evidence you shall give shall be the truth, nothing else, but the whole truth. If so, raise up your right hand and say, so help me God.
umbango sho banja toka umbango shi ke kutoka pia kapina shi toka pia kishika ke shi kutoka popo shi boshi de to fa to elo la ko lo komba to ki alunga batele so help me God.
Thanks. Sir, you must speak louder.
Okay.
Okay. Please, you must speak louder.
Okay.
Okay. You may get seated if you want to.
I want to sit down.
I'm sorry?
Sit down.
Yes, you may if you want to. Thank you. Just speak louder then.
Myself.
No, the witness.
Okay.
Yeah.
We want to hear.
Okay.
State.
Mr. Ngishiko, where do you stay?
Mr. Ngishiko Ojipeni.
Did you go finger call?
I stay in Fengerkrab.
How long have you been staying at Fengerkrab?
Only symbolic Penny or Fengerkrab. I was born there.
The three accused were before court, do you know them?
Yes, I do know them, both of them.
How is number one known to you? How is number one known to you?
How is number one, accused number one, known to you? I'm sorry, sir. Just a minute. We have accused 1, 2, 3.
Otete ndishi kuja ndalonga naye alongo security ndalonga naye no ku SAG 2016.
Accused number one, I know him because I worked with him from the security company and in this other
SSG.
And in this other company called SSG.
Accused number two?
And the paper what they take?
Ndishi ya ndakula naye mafala.
Accused number two, I know her that because we grown up together in Fengerkrab.
And number three?
And then on the tattoo?
Nonchita ndishi ndalonga naye. Kwa kula mafala ndakula naye.
Even the accused number three also, I know he said, I know him in Fengerkrab as we grew up together.
And you recall that you were once approached by the investigating officer in this case in respect of the events of February 2020, in respect of which you disposed to a statement.
What I got to chat, no, everybody moved that to kwani waenda wapo ifi kwa mapambinga ya kwa shi mashauri kile mwani wa 2020. Yes, I do.
Relate to this court what transpired in relation to this matter concerning the incident of February 2020.
Takutuana kuja elongola mangano hofa kuchoshike kwa lishaholoka mumafika atatongo February o 2020.
Ya mumafika February mu 2020.
Kapombada.
Mumafika February mu 2020 najako ko farama ndi anaka dona wangende ya mo varambata kai kuno show.
On the date of February,
February.
No
date malo date ndi timbuluka.
Doesn't remember the date, but on February 2020, remember that he drove from Fengerkrab, he came to Bella Bella to come to the show. say with my girlfriend, so.
With my
Yeah,
girlfriend.
with his girlfriend.
Ya
There.
ku Japoni tendamo show sinamo show ngo kai puno shopu show ya ja wakalati mo mixana na Bibia.
Okay, I entered the show. That show, it was like a different group. There were some colours and then other people, they are a group from Namibia. Your commission?
Ya ku Japo ishake nengo ne na David ndenkuru tangwa atupopingwa medipo ngao andiko park.
And then from there, that time, I met David, and from there we greet each other, and then from there I separated with him. I went to the park.
Who is David?
Oh, David was sure.
Oh, David number 1.
David is accused number 1.
Proceed.
Okay, ku Japoni anshake na David wensho na malukuline friend dai na tu horoteke amanjine line dange.
And then from there again, I met with young David, and then we greet each other again. And from there I proceed again. I went to my own, or with my own way. Okay.
Ku
Just
Japoni
Ian David. Who is Ian David?
But or David Insho,
David Joseph.
there is David Joseph.
David Joseph.
Yes.
Is he here?
He say yes.
Yes, please talk about the case number 1, the case number 2, the case number 3, so that I can follow the proceedings, your evidence.
On titatu.
I accuse number 3.
Yes, madam. Accused number 3.
Okay, keshine mwasha kena nani manufekelo ni mtatu David Jo.
Puonga mondayanda andika andikumbo.
From there, when I left accused number 3, I went to drive and I went home.
Ku Japoni ndakakala papita mbira mafukeli atatu ndakangwa ndili kumbo ndino malodo inu ndakataleke etua ebiema netua de apumbo letu no shilumbume ngo security no tatuma mo wambo.
And then from there, it proceeded only 3 days. And the time that I went home, it passed 3 days. And then when I was at home, I was busy sitting at home, having I'm drinking my alcohol. It's why I saw some cars, they came at home, they came at my place, and then there were some white people and with other guy, with the other uncle of Namibian nation.
Yeah.
So concerning what happened on that show weekend, is that all?
Mikishari no papita shonda kumbo.
I don't know what happened on the day that we were at the show, because that time that we were at the show, I left, I went home.
No, so na kama sasa ni great or goncha wanapo show mbele
And you confirmed earlier that the statement was obtained from you by the police.
But pena what talking one ushili statement is was saying what shall forget policy.
O statement she ya penya make ishukulesha na shindisa inifundisha ishukulesha kwa chikina design hapa nga.
When they came with a statement, only thing that what I want to tell the court, I'm illiterate, I don't know how to read and I don't know how to write. Those people, they came with a statement and they just came in to sign it.
Worship, the state would like the state to inform court that there is material deviation from the oral evidence of the witness vis-a-vis the contents of the statement in made to the police. On the stage would like to ask for leave of court to confirm the witness with the statement in terms of with a regular for applying that the statement, the witness be declared hostile in terms of section 190 of the criminal code.
Can you repeat again? Because you can speak loudly, but I'm reading like what I said my ear.
The state would like to lay the basis through a statement that the witness made to invoke the provisions of section 190 of the criminal code. That is to declare him hostile.
Onima epangelo kuchala kukula kofa kucha ohofa iyanje onima ingilo tabali kucha goye mesha mocha kwa 190 kucha ohofa iwa kucha chi kumbinga yo o betwanju umbangi
Any objection?
None.
Advocate? You may proceed.
And you can have a look at the pages of that statement where there is a signature that is supposed to be yours.
But the statement kucha kwa mape kubapila kucha kuna papa kuna shumo o cheke na
To confirm that.
Yeah, I'm the signer.
Yes, I confirm I'm the one who signed.
And you said you are not conversant in the English language.
Yes, yes, worship. I don't understand English language very well.
And neither can you read it.
No, yes, I can't read.
At the top of that statement, which is an affidavit, it indicates that the undersigned is yourself, Thomas Ishi.
But I didn't get to Talapomba, the statement I show. There's a on statement I want to read.
The undersigned is Thomas Ishi.
What about Penya Pashango, which I'm at Thomas Nishiko? You get to Talapomba the statement to pay Pashango, Thomas Nishiko. Whatever.
Yeah, do it.
Yes, I can see.
Nanwari now, we know Thomas Chibo.
And that you reside at C12 Final Club.
Eta tuku Georgie kodi mako normala hiyo kota hiyo C12 kwa Final Club. Yes.
Is that correct?
Surely.
Yes, that's correct.
Are you able to see the identity number that you provided there?
Excuse me.
Are you able to see the identity number? That is correct.
Don't kumona ID number ya shangwa.
Yangu.
Yes, I can see it.
My colleague is referring to the statement and the basis has not been made as yet. I think he indicated they want to raise the basis, but already is referring to the witness to the statement and the basis has not been made. Maybe
State.
It appears that counsel might be mixing issues. This is not a statement that the defense wants to confront a witness with, which requires the name of basis as per on which language this was made to sign it was read back to me. This is a state witness. The purpose of this statement that the state intends to show and to ask the court to declare the witness hostile is to show that what is said today differs from what is said when this affidavit was obtained from them. That is my understanding. And it appears the counsel wants the basis that the witness should confirm that materially this is what I said. That the purpose of this statement is to show to court that the witness who was called by the state, based on the statement, the evidence differs from what is said when the affidavit was obtained from them. It is therefore not a requirement that it should follow the similar process when the defense was to confront a state witness with a previous inconsistent statement.
Takutuane takutua kucha asachi we angela taki ngeshi ontikameni umfekela otibani titatisha fitamabwata uchano sachi opopiloni o tagotati tatu tatakucha wala choni mane mango nyenda pula nyo 190 kana no o pilo tango tina shime sinda kopya sachi da kopya o foko yimbe kucha sachi inimai atukopya tukula onima o mbangi komeshofa inima nyata kopi ya yolo kana ifana na nya ashagiba ko mako ko statement ya anja ko na police
moya nase asibonje itaba yaboncho hlazi twabule mo statement isemo isibile mo pelenga amapolice asawa jo nje mo abi sentela
Defense?
the basis is, the facts of it is a statement. And at the end of the day, and this is what happened on the previous occasion, the state will be asking that the statement be admitted in evidence. And the court is going to be marking the statement as an exhibit. Now, we are saying this statement, which is indicating as evidence that they came with the statement and they was asked to sign. We expect the state to at least indicate that that was actually is what he told the police, and what was in there is exactly what he told the police, and he understood. All that basically needs to be laid before the court could, because the problem is at the end, a request will be made or an appeal will be made that the statement be admitted in evidence, and the admissibility of it becomes an issue. That is what we're saying.
I don't understand. You expect what?
To lay a basis on this statement, that this is
The states, this is
the witness statement. Before they could ask him on it, at least that basis. It's a general principle of this statement, of a basis being laid for the statement.
I understand. I thought that he showed him the statement and he asked if, is this your statement? Is this your signature? He said yes. Is this where you stay? He said yes. What is lacking in your view?
But it's a whole lot that is lacking.
What is lacking? The state said it is not necessary. There are two, according to the state say it is not necessarily. This differs from a situation whereby now the witness is in the witness stand and has testified. The defense needs to cross-examine the witness based on the statement that he made. When the witness said, no, I know nothing about this. He said it's not a requirement to follow the procedure like the ones that it is follows when the defense has to cross-examine the witness based on the statement that he made.
And that is where we differ.
Yes.
Because this is a statement which the court at the end is going to be heavy in its possession, and a statement, the content of which the court is going to have regard to, which the witness has said. They came with this statement, and I was then asked to sign.
To sign, yeah, that one I had to.
Yes, and that is where we're having a problem to say at least we need to hear more on this issue. And if a trial needs to be, the root of the trial has to be taken, that has to be taken. That's my thinking. Because for him to be told of a statement and the next moment crosses the line of a statement which he has indicated, I just signed.
I think your instructing attorney has given you something, showed you. Maybe it's a case law. It's a case law, or it's something. Can you look at that and address me on that, please? Case
statement yambiyetula yashangwanale shashana kandi shikulesha kandi shikushanga amudetlo ku statement kujana design iko pu
It is basically on that admissibility of the statement. At the end of the day,
Oh, I thought that you have something to support you to substantiate your submission and argument to say this is in case whatever this is what had happened. Court resumes after lunch break. Defense? Rex versus Wheelers. I'm sorry, W-E or I? W-E-L-L-E-R-S. Yes. TBD 234. Paragraph 2372 2238 238.
I'm going to refer to that paragraph where the court highlighted that in such a case it is necessary in the interest of justice that the examining counsel should be allowed to cross-examine the witness and to show that he really perceived the particular thing, which we are clear about that. It says his statement must be put to the witness and he must be asked whether or not he has made such a statement. Now, this is just the part that I want to say. You must be asked those questions. That is now. He could just needed to be put on.
But was it, okay, continue.
Yes,
Was he not asked about the statement, whereby he also confirmed that the signatures?
I confirmed the signature, but that is where he said they came with the statement.
I'm sorry?
He said they
Yeah, but that is another issue of having made, whether he made the statement voluntarily and freely. That is another issue.
And which issue now will we have to have as to whether we have a statement in the first place that he made? Because he must be asked whether he made that statement. And if he says they came with the statement and made me to sign, question is, did he make that statement?
Yeah, but is it according to this case law?
That is what they say.
Okay, proceed.
He
Proceed.
must be asked whether or not he has made such a statement. It seems to me clear that any previous statements made by a witness who is called, say, by the plaintiff, which type of this statement gives in the witness box ought to be placed before him. And if he admits it, it ought to be brought to the knowledge of the judge. Now, it has to be brought to his attention, and if he admits that this is actually what I have done, then it must be brought to the attention of the judge. Now, another case which is the Makala matter.
I'm sorry?
Makala and other.
Makala and other.
The KHA.
Makala and other.
Yeah,
Another. Yes. Just a minute. Versus date? 2022. Volume 1. SACR 485. Yes. 485.
Yeah, 485.
Paragraph 1. 111. Yes. 21115.
Purposes of impeaching him or her and may not be tendered into court as proof for the into evidence as proof of the facts, as proof of the facts contained in that statement, which we had a discussion according on that fact to say in the event of proceeding, then the tendering of it, which we also had a situation of in respect of the previous one, but the tendering of it cannot be accepted as in evidence as proof of those facts.
Yeah, but remember, if the statement is tendered in, does not necessarily mean that the court accepts what is in there. The court will consider the overall evidence of the case and make a decision. The fact that the statement has been admitted or handed in court as exhibit does not necessarily mean that the court will say this is actually what had happened. Not so.
That is correct. Let's say now those statements as they are accepted, they should be accepted in relation to the specific inquiry that we are busy with. Like in the first one, the inquiry of the 189, that is specifically for that.
Yeah.
In respect of 190 is specifically in respect of that is basically the position of which we've said now, if you are to proceed, but the problem we are sitting with is there a statement that he made?
Because of the issue you raised that he alleges it was not made freely and voluntarily.
It was not made by him at all.
It was not made by him. It is not a question of freely and voluntarily. It must. That's why I'm saying, because of the allegations that the statement was brought to me, I was just ordered to sign. I signed.
And now that's why we are ready to say we do not have any detail from him as to whether there was an interpreter or such. But at the statement, cut of it is there wasn't a statement that he said he made. The statement that he says he said it was brought to me, I signed. Is there a statement that we are sitting with that the state will say I'm going to use this to impeach you? Maybe.
Thank you.
Yeah, and then like start where from the beginning. I don't know should I begin from when they ended.
What?
We were talking about like the case from Willa to Makala, all of those things, because it was a little bit
It's a little
long paragraph. So that if they can start it again so that I can interpret it in a good way so you can understand.
Yeah, if it's a long paragraph, you should indicate that he must stop. You interpret. It will be better that way.
That's what I wanted.
Okay.
That's why I was just waiting for him to finish.
Now, if you wait for him for finish, you want him to start again. Please, for the interest of justice and for the witness and also the accused to understand what is going on, can you just say it briefly, then the interpreter interprets so that they can understand what actually is going on?
Yes, the crux of the submission was basically that the witness testified that he did not make a statement. The statement was brought to him to sign.
Takuwana kucha oshima shishaitwa kwa makomesho hopa oshina shaitwa kucha ombangi nisha mova tucha umbangi mnyelo statement nisha shangifa ina kwa meisha kaka owe umbangi nya owe tira kucha obo usaina umbangi otoposho kauya owa nyuko polisi.
And if there is a statement that has to be cross-examined on or to be impeached as is concerned, the question remains that is there a statement that ought to be cross-examined on? There was no such statement.
Takuwana kucha kulumbangi naleta bani kanota kwa mofa utata bakala uno makulu oshina tabapula uchanya oshina umbangi unyane tabapula ne mofa kucha unyakula makulu kucha umbangi wa shito pouli.
Thank you. Mr. Matlala?
I concur with my interpretation.
Thank you. State?
Thank you, Your Worship. Well, I thought there was some common ground regarding how we should proceed with this matter. However, let me indicate that the authority that was cited, I think he read somewhere where he said that statement must be put to the witness. For the witness to say whether this is what I said and this is what I said. And that's where I was going with the statement. It's not the requirement that he should first confirm that it's his statement. What would be the purpose of using that statement? Because that would be self-corroboration if it was a statement that we confirm that he used. And in the commentary, there are 3 causes that are said to be open to a party who is alleging that the witness is unfavorable to him. And this was confirmed from it stems from the English law, and just indicate that it was confirmed in our law in the case of Van der Linde versus Kalitz.
Van der Linde versus Kalitz. I'm sorry?
1967.
Volume
2.
2.
SA.
239.
Appellate Division.
A.
Where it states that where a party calls the witness who gives evidence which is unfavorable to him, there are 3 causes open to such party. Number 1, he may need evidence to contradict the unfavorable witness. Number 2, he may ask the court to declare the witness hostile, thus allowing the person who will call the witness to cross-examine him. Number 3, he may prove a previous inconsistent statement made by the witness in terms of subsection 2, which then means...
Just a minute.
Which then leaves the state with options on how to approach the process of impeaching such a witness, which includes showing to the court that there was a previous statement that was made by the witness, which is inconsistent with his oral testimony. And also in SSS Beja and another. Bracket CC 18 of 2021.
CC 18 2021.
Brackets in semicolons 2023.
2023.
ZAW. CHC.
CHC.
113. Date of hearing 19 May 2023.
19 May 2023.
It also dealt with the application to declare a witness hostile. Paragraph 9. It states the application by the state was very narrow. The state asked the court to declare the witness hostile. This was aimed at allowing the state to cross-examine its own witness. This is because the rule is that a party may not cross-examine its own witness unless the court forms an opinion that the witness was hostile. Forming an opinion that the witness is hostile.
That case was for 2021, so 2023. At the one which I cut on by name of the show, and then they were on by worship law, but you know, with a name of Alpha of no, we Pangro. I do, we are over, which are all Pangro, which are ever law or we told which are a quite of Jaffa or Tishombani, Kaino Shinkai.
I must indicate that forming an opinion is not proof beyond reasonable doubt. And the state is of the view that it will be sufficient for the court to make an opinion when the state brings it to the attention of the court that what the witness said today is in contrast with the statement purported to be his made during the course of the investigation. In that case, the court also quoted what was said in Rex versus Vellers, 1918 GPD 234, where the court stated, then we have a third class of case where a person approaches a party, tells him what evidence he can give, and then goes into the box and tells a diametrically opposite story adverse to the party calling him. The witnesses in this case deceived the party into putting him into the box. In such a case, it is necessary in the interest of justice that the examining counsel should be allowed to cross-examine the witness and to show that he really deceived the party calling him.
chairman ai pulo ni ma o mbangi o mapulo o kucha o rike mutashiri mapulo ndo kwa to shiki yo to fuke o bakaya
wala ke le o ko ko kama tlhakuleng mo ba ditšhatsone ba futsela sa o tšhetla tse o diputšisho ka go tšhela mo bana a o a tseng a e mo a se ka mena mo tlhakuleng.
His statement must be put to the witness.
What are the statement I will chamba wa chamba.
And he must be asked whether or not he has made such a statement. It seems to me clear that any previous statement made by a witness who is called say by a plaintiff, which entirely contradicts the evidence he gives in the witness box, ought to be placed before him, and if he admits it, it ought to be brought to the knowledge of the judge that he has made. That he has made to the party calling him an entirely different statement from what he is stating in the box. That being so, the judge will give leave to cross-examine the witness, and if he has made a contrary statement previously, dismiss his evidence as not being trustworthy. Paragraph 10 stated that sentence no longer represents the court approach. The new approach was set out in Phala Phala, the case that the defense has already referred the court to Phala Phala. SSS.
Can you repeat the statement against him?
In Makala and another versus S, the authority that counsel for the defense has already referred the court to, the following was stated. It is a long-standing rule of our common law derived from English law that in such cases the state witness's extra-curial statement may be used solely for the purpose of impeaching him or her and may not be tendered into court as proof for the facts contained therein.
As I've already submitted earlier, the approach in the declaration of a witness's hostage is distinguishable and different from the approach to be used when an opponent intends to cross-examine a witness of the other party on the contents of a previous statement. Given what has been said in the authorities, it is my submission that the state is entitled to put the contents of the statement into the witness for him to confirm whether or not it is his statement, which has been heard by the state, is favorable or is hostile to the state. And if the court does not ordain that approach, the state will then submit that in that event it will result in a trial within trial being held for the state to prove that the statement that it is relying on was made by this witness.
Thank you. I'm interested in what you have just said now. In this case of R versus Willis, 1918, TBT 234, you said the court said the witness must be asked whether he made such a statement. If the answer is to the effect that I did not make a statement, what should happen?
I think what the author should say is that must be, the contents of the statement must be put to the witness, and he says, no, I did not make this statement. I did not say this. And this is for the purpose of the inquiry into whether it should be found to be hostile or not. But I think it's saying the statement must be put to that whether and we confirm. My understanding is that you read what is in the statement and he says, no, I didn't say this to the police. I didn't make this affirmation that is contained in my statement. That's my understanding. ame statement yayo ndiye tereke yashangwana ne amonde andi sign iki kwa
further submit that is the reason why in the end we say that statement when it's tendered, it should not be tendered to prove the contents of the statement, but just to show that there are contrary versions that the party who's calling the witness has and the actual evidence that the witness has.
Not to prove. The witness already said, state. The witness already said that I never made the statement. The police brought the statement to me and said he must sign. I signed.
In that regard, Your Worship, the state would like to then request the court to direct that hearing, trial within trial be held so that the state can use evidence to prove that the statement was made by the witness.
State. In that case, we have a witness now. And if we were to hold a trial within a trial, it will mean that you'll be calling witnesses. And these witnesses have to be cross-examined. So, is he the one who is going to cross-examine the witnesses? Because he is now involved in this trial within the trial. He will also be given an opportunity to testify. But the issue of cross-examination, how then should we approach that? Do you understand me?
Yes, but yes, Your Worship, as a party to the proceedings, it should be given an opportunity to cross-examine the witness that the state will call to lead its evidence showing that the statement was made by him.
I'm asking this now I'm not sure about this, I must, in view of, because the defense, these legally trained people, they are not representing him per se. They will still be given an opportunity to cross-examine. Is he not entitled now to legal representation? This is what I want to hear your view on.
Now, according to authorities,
He is entitled.
Legal representation. The only thing that the authority says is not entitled is what they say. So he is entitled, but the court is not supposed to assist him to secure legal representation because he's not the Section 35 arrested, detained, or suspected person.
Is it?
But he is entitled.
So the court is not supposed to help him.
No, what he says, yes.
The court must act in the best interest of justice at all material times, regarding witnesses, regarding accused, regarding whoever.
We are not a commentary which says, I think they also make reference to matter. It's a witness before being declared hostile, entitled to legal representation for the purpose of such a decision by a court. Yes, said the court in Macau. But does the witness have the additional right to be provided with representation by the court? Until AJAS then was agreed with the trial court's view that there was no such entitlement, since the witness was not an arrested, detained, or accused person as contemplated by the Constitution. The Constitution distinguishes difference as to legal representation, said the court. In terms of Section 35(2)(b), a detainee has the right to choose and consult with a legal practitioner and to be informed of that right. Section 35(f) gives an accused the right to choose a legal practitioner and not represent the law person. 35(3)(g) gives the accused the further right to have a legal practitioner assigned at state expense if substantial injustice will otherwise result. No provision, however, is made for a witness to be provided with a legal practitioner. But however, said under AJA, a court is invested with the inherent power to conduct its proceedings fairly, and that may entail, in a particular case, that the court should give proceedings to legal practitioner being assigned to assist the witness, which is what the court was saying. The court is entitled to consider in the interest of justice that he be assisted by a legal practitioner. As a purpose.
coming while you tackle coming over, go over, or you coming over a better in the campo.
Mr. Deshiko, the issue here is an application by the state in terms of Section 190 of the Criminal Procedure Act to declare you a hostile witness. According to the state, apparently you may be deviating from the statement which you allegedly made to the police. That is why you were showing the statement, and already is on record that you said you never made such a statement, but however, you allegedly said that the police brought these statements to you and said to you must sign, and you signed. There was an objection as regard to the procedure which need to be followed in this regard. But however, it's apparently become clear to both parties that even if you may be approached with the state's statement and the court allow the state to cross-examine you on the statement, that will not necessarily mean that the statement can be handed in court in order to prove the facts of what had happened. I have been referred to case law authority by both the defense and the state as regard to how this matter can be approached. But what is of interesting is what has been raised by the defense to the effect that a certain case law said, because of the fact that you alleged you did not make such a statement, it is like as if there is no statement which is before court that has been made by yourself.
toke article ni ya kutawa kama kwenye watu wa no toke kwetu kutashi statement ya ndo kwa mshofa statement ni ya ndo kwa mshofa na mara wakati o bangia statement ya ndishanga ilo habika ni ngashanga nishungana okay ndawo ndagene nditata eto kwa shala shofa itatukata shiri ujao atuka pula ujao statement of shiri oishanga ilo oishangelwa kushona nitafuta mimi maili nenda openda tele na uta ameshakanja kumbango wa kuna batoko mtani tukaduje toko kwa shiri jo nyuma statement of oishangelwa habika oishanga
And the state said, should the court then agree to the effect that there is indeed a challenge as regard to the statement on the basis that you alleged you did not make any statement, but it was brought to you only to sign, the state will then make an application for a trial within the trial to be held in order to determine the status of this particular statement. I need time to consider these arguments and also to look and consider the case law authority that has been referred to this court by both the state and the defense. For that reason, the court would tomorrow give a ruling as regard to this issue. The court will make a ruling tomorrow as regard to this issue. I can see that the parties, the defense and also the state start to whisper how, because tomorrow is not scheduled for the proceedings of this case. I will make a ruling and it will be circulated to all the parties electronically in order to expedite the finalization of this matter. And And also yourself, I will request that you leave your details with the clerk of the court, of this court, for you also to receive the said electronical ruling or judgment. Do you understand? Do you have witnesses here?
I still have 2 short witnesses who can proceed.
They're here. Is it? They will be short. So are you suggesting that we stand the evidence of this witness and proceed with the other witnesses? That's true. Thank you. Defense?
No objection.
Thank you. For your case, the matter is postponed until Friday, the 3rd of October. Just a minute. For further trial, you are warned 8:30. This court failure to come. Warrant of arrest will authorize against you. Do you understand? And you are still under oath. Date?
On Friday.
What time?
On Friday.
What time?
Pongapi?
9.
Half past 8.
8:30. Do you understand?
There's 9 half past 8.
And you must not leave, you must provide clerk of the court with your details so that we can also send a ruling to you. Understand? Can you help take him to the clerk of the court, please? They will help you there. Miss Catleon, you are excused.
You say you want to ask a question?
Yes.
Problem here, I was working and at the time at the assignment to come to court, and they even told they phoned me, and even the end of this month I didn't get paid, and then they told me that I must finish up my thing. I thought that I could be finishing by tomorrow, so that I can go back on Friday to work.
Yeah, unfortunately, this matter was not scheduled until tomorrow. It's for today and Friday. They may give you a letter that you can take to your employer. They will help you with a letter, do you understand? To give to your employer. You may email or fax the letter to them because they will be expecting you on Friday. You understand? Thank you, you're excused. State.
Michael,
I hope that the witness that is coming, we must not experience any problem. problem that will stand the matter. I mean, his evidence, we must finalize the evidence.
I don't see any.
Thank you. Michael? Thank you. Your full name and surname, please.
Sorry. Michael Drummond Abreu.
Michael
Drummond, yeah.
Drummond
Abreu.
Abreu. Sir, do you understand what is meant by oath?
Yes.
Do you have an objection in taking the prescribed oath? You must not do like
Yes.
this. Do you have an objection in taking the oath?
No.
No. Do you consider the oath to be binding on your conscience to tell the truth?
Yes.
May you swear that the evidence you shall give shall be the truth, nothing else but the whole truth. If so, raise up your right hand and say, so help me God.
So help me God.
Thank you. You may sit down.
Thank you.
And speak louder.
Okay.
Thank you. State.
Thank you, Worship. Mr. Abreu, you are cited as complainant in count number 2 relating to housebreaking, to the offense of housebreaking with regard to state that was occasioned at Stokes Drive Farm.
You may proceed.
And can you tell the court, Stokes Drive Farm, are you employed there, are you the owner of it?
At that time, I was the owner. I did sell the farm 2 years ago.
And you remember the events of 9 February 2020 with you to Stokes Drive Farm?
Yes.
What happened?
I received a call. I stay in Pretoria, so I received a call from one of the contractors to say that they think there was a break in my house. I then contacted my new farm manager and asked him to go and look, and I also drove through. We then went through, we saw that there was a break-in by the window, and we went through the camera footage because I did have cameras, and we saw a couple of guys coming in, and they took the pillows out of the pillowcases.
And then it's not that much fun. But now I'm not sure of what I'm going to be.
Then asked Sean, farm manager, to go to the police station and open a case, but we couldn't find anything missing in the house, so we didn't think that anything was stolen.
How many of others, the cushions that were removed, what were they for? Were they for sofas, were they for chairs, or
Sorry?
the cushions that were removed, were they for sofas, couches, chairs?
It was on the beds and on the sofas.
But if I may retrieve this, which I think is I'm reading photos number 58 to 59. Just for you to browse and confirm if you know the list depicted in those photos.
I can confirm all of the photos are of my house that I owned on the farm.
And in those photos, are you able to see the photo depicting the window that you said was tempered?
Yes, sir.
Which photo?
Okay, let me go through because it's photo 56, 57, 58, 59. And the burglar bars that you see on the photo are installed after the event.
And then the burglars of those.
The last one.
The
burglar bars,
yes.
The security bars are installed after the break-in. It wasn't there when the break-in happened.
And you indicated that after investigations you could not determine if anything was stolen.
Yes.
Thank you. Mr. Matlala, any cross-examination? Thank you. Advocate, any cross-examination? Thank you. Thank you, sir. You may stand down. You are excused.
Thank you.
Thank you, Your Worship. In the absence of any cross-examination for this witness, I will only it will not be necessary for me to call the next witness. I will just call him for the court to excuse him. Sean Weber.
Sean Weber.
Just for him to be excused, that will be all the evidence.
Okay. Your full name, sir?
Sean Weaver.
Sean Weber.
Yes.
The state, the prosecutor is no longer going to call you as a witness. You are then excused.
Okay. Thank you very much. Thank you.
Defense, are you going to call him? No. Thank you. Excused.
On that note, if the matter may be brought to
Friday. Friday, how many witnesses do you have?
I think for them.
They must come.
They are not here.
Oh, I mean Friday, they must be here. So. Postpone. Friday is the 30th. Come forward. Today we started late because the witness arrived late and we are wasting time. We still have a long way to go. Please talk to your witnesses. They must be here 8:30, 9 o'clock we should start, so that we can help many witnesses. Otherwise, to deal with 1-2 witnesses a day, I'm not happy about that. Just tell them, please, 9 o'clock, I want to start with their evidence so that we can expedite the finalization of the matter. Thank you. You may stand. This matter is postponed until the 3rd of October, this Friday, for further trial. Number 1, you are still in custody. Number 2 and 3, on extended bail. Warrant of passage, this court failure to come. Warrant of arrest authorized against to bail money forfeited to the state. Do you understand? Number 2, do you understand? 3, do you understand? Thank you. Court adjourns.